We're recording.
Hi, everybody. Welcome to today's webinar for our Know the Law series on small claims. My name's Deb. I'm with the Law Library, and we're happy to have Wayne here today. I'll introduce him in just a bit. But while I'm going to watch as participants come in, we've got a nice crowd coming today. I think about 35 or 40 people are coming. So while we're letting the participants join in, I'll chat at you a little bit about some housekeeping issues, and then I'll turn it over to Wayne and we will continue with the class. So San Diego Law Library is happy to present this class. We present a number of webinars on a number of different topics, both for lay people and professionals. And you can stay on top of what those are by going to our website, sdlawlibrary.org, and looking at our classes page. And you'll find there some free seminars, as well as some for cost MCLEs. And you can also go to our YouTube channel, where you can see a lot of the past classes that we have presented, queued up there in video format, and those are all free all the time. And you can access them any time of day that you want. So today we're going to be listening to Wayne speak about small claims, and you may have questions as the program progresses. If you do, please put them in the Q&A section of the Zoom, not the chat section. And we will get to those as we're able throughout the class. Also, at the end of the class today, you will be getting a little survey, and we'd sure appreciate that if you would fill it out and send it back to us. It helps us provide better programming and know what you need and how we can meet your needs to provide more webinars for you. So today, I'm very, very pleased to welcome Wayne Templin to speak on small claims. Wayne is a San Diego attorney, and I would not fulfill my duty today if I did not tell you that Wayne is one of the original creators of this Know the Law program. Know the Law is a partnership that San Diego Law Library has with the North County Bar Association, and Wayne was one of the creating forces behind it years and years ago when it was known as the People's Law School. And it's gone through a few iterations since then, but we are very indebted to Wayne for his industry and creativity and dedication to public service in this series, which is now taking on dimensions no one could have anticipated by doing it on Zoom for anybody who cares to orb in. So Mr. Templin is a founding creator. He's also a San Diego attorney, as mentioned, but of great relevance for today is he has served as a small claims pro tem judge for over 25 years in San Diego County. He has heard it all, he has seen it all, and he has stories he will tell you, and he will guide you through anecdote and law so that you can have a really good experience in your small claims action. So without further ado, I'm going to disappear myself, but I'll be lurking in the background. I'll hand it over to Mr. Templin and take it away, sir.
Okay. Thank you very much, Deborah, and I really appreciate you emphasizing my age. It really makes my day. Thank you. I will be able to pay you back for that at some point in time. One of the problems with the Zoom meeting is, of course, I'm not going to have the interactive talks with the audience out there. So I'm going to go through the material. I'm going to go through the material fairly quickly. If you have questions, please type them into the Q&A box, and I will get to them at the end of the program. So there's a lot of material. I'm going to go through the basics of the procedures for small claims, the basic concepts of small claims court. And then I'm going to try and spend most of the time at the back end of this presentation discussing how to present your case at the time of the trial. I've taken a little bit of time to watch some virtual trials, which is what's going on right now with small claims. And I can give you some ideas about issues and problems that the court is having in the virtual trial area. And hopefully that will help with your particular case. Okay. Small claims court is a very busy court. Right now, it's even more so. Typically, the small claims division in the county does anywhere from 40 to 50 cases a day. And right now, they're trying to catch up, and they're doing anywhere from 90 to 100 cases a day. I believe there are 6 courtrooms right now hearing small claims cases. So it is a very, very busy calendar. Let's go here. And what we're going to talk about today are the basic purposes for small claims court, the procedures that are involved in small claims court, how to present your case, and some post-judgment procedures. Okay. I'm going to be trying to do in an hour that is something that would probably normally take 3 to 4 hours to go through if I were going to do everything. So I'm going to hit the highlights. I will emphasize strongly that you also do some of your own research by going to either the San Diego Superior Court website. They have a whole bunch of links that you can click on that give you helpful information. Another link is the Judicial Council for the state of California. You can find all the small claims forms at that particular website. Take full advantage of them before you do your small claims case. And as soon as the phone stops ringing, it is now off. A small claims court is designed for relatively minor disputes, but there is now going to be a big exception to that, to have them resolved quickly and inexpensively and hopefully fairly. There's no juries, there's no attorneys involved at the initial trial, there's no formal pleadings, rules of evidence, with one exception, and there are no findings by the court in small claims court. In terms of evidence, the judge that's going to hear the case is free to consider all kinds of evidence, including hearsay evidence. What the court is allowed to do is reject evidence that it feels is not relevant to the case. So you can bring in documents or letters from people, but if you start talking about something that's not relevant to the case, the court can interrupt and tell you to move on. The judicial officer that's hearing the case has a very short time to hear the case. There might be anywhere from 10 to 20 cases on your particular calendar. So the court has limited time in 3 hours, give or take, to hear your particular case. So that means, among other things, you need to be prepared and succinct. Okay. Now, the judge in small claims court has a unique position. Unlike judges in other departments, the small claims judge can contact witnesses informally after the trial, contact expert witnesses. The judge can do his or her own investigation if they want to do that regarding your case. Judges in small claims court typically take a very active role. They will ask you questions. They will ask you about your documents. They will ask you what happened, who said what, and when things happened. They may also ask you some questions about technical issues. For example, when did the injury occur? Where did it occur? Is this related to some sort of special consumer product or situation? All of these questions are related to technical defenses and claims that may be relevant to your case. The judge is not supposed to take one side or the other, or appear to take one side or the other. Okay, small claims cases are typically cases for money, and with an exception that is probably going to be a big issue beginning October 1. Small claims cases can be brought by individuals. Limit is $5,000, except for a natural person, that's a human being. If it's for the recovery of money, then you can go to $10,000. Otherwise, for other entities like corporations, partnerships, business entities, the limit is $5,000. Right now in California, You're allowed to have two small claims limit at the full, excuse me, two small claims cases at the full limit amounts. Your third case is going to be limited to $2,500. Now, effective August 1, COVID rules for small claims court will begin. And those rules apply to what are called COVID rental debt. If you are a landlord suing a tenant for unpaid rent or financial obligations under a rental agreement, there is no limit to the small claims jurisdiction. The small claims court can hear a $20,000, $30,000, $40,000 case if it involves COVID rental debt. One of the rules to keep in mind if you do have that kind of situation coming up is code CCP 871.10 requires the plaintiff to have documentation attached to their complaint regarding a good faith effort to investigate rental assistance for the tenant. That's one of the requirements of bringing your case. Okay, now jurisdictional issues that come up frequently. The typical small claims case is one plaintiff and one defendant. But if you're a plaintiff and you have two defendants or more, you can bring a claim against two or more defendants in one trial. If the defendants are jointly liable, then the maximum limit for small claims court, it will be either $5,000 or $10,000 unless it's COVID rental debt. If you have multiple defendants and the defendants aren't jointly liable for the debt, whatever it may be, you may have, for example, in an automobile accident case, you may have two defendants, two cars are defendants. In that case, you can bring up to the maximum jurisdictional limit against each defendant. Okay. When the plaintiff has separate claims against different defendants, small claims is unique in the sense that a plaintiff can bring multiple claims against different defendants in the same case. So in that particular situation, if you've got separate claims against different defendants, your limit is the maximum available as to each defendant. So forgetting COVID rental debt for the moment, you could bring a $10,000 claim against one defendant in the same case as bringing another claim against another defendant in that same case. So potentially your maximum could be $20,000. Parties are allowed to waive the amount, excuse me, if a plaintiff brings an action for, say, $15,000 in the small claims court, if the plaintiff proceeds all the way through trial, the plaintiff will have waived the amount above the jurisdictional limit in effect at the time of the trial. So if the plaintiff brings a $15,000 claim for property damage, say for example, automobile collision, car hits your car and causes damage, repair cost is $15,000. You bring a small claims case. If there is a trial and judgment entered, your claim will be reduced to $10,000. So keep that in mind. When you bring small claims court, you are limited, again, with the exception of COVID rental debt beginning August 1, to $10,000 for individuals, $5,000 for businesses. Okay. Sometimes plaintiffs are involved with defendants where there are a series of payments involved. Typically, it's a landlord-tenant situation where the tenant has failed to pay the rent for a number of months. But it could be a contract where somebody owes you money and is paying on the installment method. In small claims court and in any court in California, in these type of cases where there's a series of payments that have come due, you are obligated to include all of the payments that are due as of the time you file the complaint. So what that means, for example, as example in the display, if you have a tenant who owes $2,500 a month and hasn't paid for 8 months, you have to sue for all 8 months at one time. So even though, excuse me, forgetting COVID rental debt for the moment, so even though the claim might be $20,000, you would be limited to the $10,000 limit. If you have a situation where you've loaned money to somebody and they're paying you on the installment method, when you bring your small claims case, you must include all unpaid, unpaid amounts at the time of the filing. If all of the unpaid amounts exceed 10,000, for example, if you have a contract, you loan somebody $30,000 and they're paying you $1,000 a month, and they haven't paid you for 15 months, when you file your small claims case, you are going to be limited to $10,000, even though the person owes you 15. You are not allowed to split out the claims into two separate lawsuits in order to recover the full 15,000 amount. That's called splitting a cause of action, and that is not allowed. Okay, venue. Venue is where do you file the small claims case? Okay, typically in civil actions, and small claims is true like other civil actions, you usually file it in the county where the defendants, or some of the defendants, if you have more than one, reside at the beginning of the action. If the action is based on a contract, in the county where the contract was to be performed by the defendant or where the contract was made. For example, you may enter into a contract in San Diego for performance by a defendant in Orange County. So if you're the plaintiff, you have the option of either filing in San Diego or in Orange County. If the action is based on injury to person or property, automobile accident, personal injury, bodily injury, house damage, you need to file it in the county where the injury occurred. Corporations or businesses, associations can be sued in the county where the contract was made or to be performed, where the obligation or liability arose. In other words, the county where the breach occurred. The corporation or the corporation's principal place of business. So, for example, the contract may have been to be performed in San Francisco, but the place of business for the business is in San Diego. So you have an option of filing in San Francisco or in San Diego. Okay, contracts, and you see this a lot in consumer contracts and other kinds of contracts where they have a venue provision that says if a lawsuit's filed, it has to be filed in this particular location. Those are venue paragraphs, and those venue paragraphs are permissible as long as they comply with the statutes related to venue. If the contract provision for venue violates or doesn't comply with state statute, it is not valid, and the statutes will determine where the case is to be filed. Challenges to venue. If a defendant thinks the lawsuit's filed in the wrong place, the defendant can send a letter to the court contesting the location and ask that the court either dismiss the case, which is typically what defendants do, or move the case to a more appropriate location. Generally, if the small claims case is filed in the wrong spot, the small claims case will be dismissed, requiring the plaintiff to file in the correct location. Again, if you're a plaintiff, it's really important that you find or file your lawsuit in the correct area or the correct county in order to avoid it being dismissed and having to refile someplace else. The court can transfer a small claims case within a county, and in theory, a court could transfer a small claims case to another county, but that never happens. So if you file for, it used to be if you could file in North County and it was actually supposed to be filed in El Cajon, the court could move it from North County to El Cajon. But because all small claims cases are downtown, that's no longer going to happen, at least for the near future. If there's a venue challenge and the court finds the case was filed in the right location, if everybody appears at the time of the venue challenge, the court will ask you if you were ready to go and may hear the case that day. If not, or if not everybody is present, if not, people aren't ready to go that day, or if everybody is not present, the court will continue the trial of the case for at least 15 days. Typically, it's going to be 30 to 45 days, and then the trial will be held at the new date. Okay. Small claims is started by filing a small claims form that's available from the court website. You can also download it from the Judicial Council website. Right at this moment, small claims does not have e-filing available. At least I haven't seen it at the court website yet. I'm assuming sometime in the near future that will change. Normally what you'll do then is fill out the form and take it to the court for filing to the court business office. And at the time of the filing, they will give you also a court trial date. Just as a note, you can ask the clerk to set it for a different date if you want to when you take it in, if it's more convenient for you. Typically, they will set small claims trials out about 45 to 60 days. And if you want some additional time, you can certainly ask the clerk for a later date or a different day of the week. If Mondays are good for you and Tuesdays are not, ask the clerk to set it for a Monday, that type of thing. You are required to use a Judicial Council form. It's Form SC. SC is, of course, stands for small claim, Form 100. As I mentioned earlier, if you're suing for COVID rental debt, you may need to be attaching additional documentation showing your attempts to determine whether rental assistance applies to your tenant. Okay, small claims actions can be filed by any individual 18 and older, or under 18 if they're emancipated, as long as they are competent. And this is true with any civil action that an individual files. Small claims allows corporations, partnerships, limited partnerships, LLCs, associations, and other entities to file actions. Trustees of trusts, which are more common and bringing more litigation, are actually, they're considered an entity, but technically the trustee is an individual. And as long as the trustee is 18 and older, which they almost always are or should be, it's okay for a trustee of a trust to file in small claims court. If you have a minor, somebody that's under the age of 18, they can be a plaintiff, just like in the regular civil case. They can be a plaintiff in a small claims case, and they can be a defendant in a small claims case. Typically what will happen is the small claims judge will be asked to appoint what's called a guardian ad litem. It means a guardian at law. That's a representative for the minor, and that will typically be a parent or other relative. So if a 16-year-old is a defendant or a plaintiff, they should have an adult with them that can be appointed as guardian ad litem for the purpose of the small claims case. Okay, as I mentioned, trustees and bankruptcies can also be plaintiffs, and some other kinds of plaintiffs you might run into, hopefully not if you're a defendant, is being sued for security agreements, for example, car installment agreements, things along that line, those folks can be plaintiff in small claims court. An assignee, someone who has bought a claim, is not allowed to be in small claims court. This happens typically when a book of business, for example, credit card debt, is purchased from a credit card company, and a company is suing in small claims to collect on the credit card debt. There are exceptions in the code, or the way the code's written, it may allow the person who purchased a book of credit card debt to sue, but it's very, very limited and under limited circumstances. So if you've got a friend that has a claim and doesn't want to sue and wants to give it to you and tells you, go ahead and sue for me, or I'll pay me some money and I'll sell it to you, small claims court is not the place you're going to end up in. You're going to have to file a civil action, either as a limited civil case or an unlimited civil case. Okay, joinder of parties. What that means is, in small claims, like other civil actions, you can have more than one plaintiff. You can have two plaintiffs suing one defendant. Doesn't have to be husband and wife. So typically in small claims court, you'll find a situation where a husband or a wife is injured in an automobile collision and the other spouse is suing for medical expenses or other expenses related to the automobile collision. And that's the more common situation of a joinder. But two or more plaintiffs can also be done in one small claims case against one defendant if each of the small claims plaintiffs has a claim against that particular defendant. Each small claims plaintiff is limited to the maximum amount. Typically, what you'll see in that kind of situation is some sort of consumer action where you have a business that has done something involving numerous people, and all of the people want to get together to sue that business for that behavior. Normally, you'll see people talk about a class action kind of case. It's not class action. It's individual plaintiffs, but the concept is multiple plaintiffs who, for example, purchased product from a store and the product was defective, and a whole bunch of people, 5, 10, or 15, want to sue this store for selling a bad product. That's another claim that's available in small claims court, another situation that can be done in small claims court. Plaintiff can join two or more defendants. So one plaintiff can join two or more defendants. Even if the total amount against each defendant is more than is 10,000, and the total against all defendants is more than the jurisdictional limit. So you're limited to 10,000 as to a defendant, but if you sue 3 defendants and you get a judgment for 10,000 against each of the defendants, then you can recover 30,000 in small claims. These kind of cases are typical where one plaintiff has dealt with a number of people in a transaction. For example, a real estate purchase situation where the buyer of a house claims the seller failed to disclose, the seller's agent failed to disclose some defect, a home inspection company missed a defect and didn't tell the buyer about it. That's a kind of case where you have one plaintiff and 3 or 4 or 5 defendants. Okay. If you have 2 or more plaintiffs that have a joint interest in the claim, the 2 plaintiffs together cannot recover more than the total of the jurisdictional limit. So for example, in a rental context where you have 2 tenants who are suing under a rental agreement, the 2 plaintiffs are a joint plaintiff, and the maximum recovery for the 2 plaintiffs would be a total of the jurisdictional limit, for example, $10,000. Just as for a terminology point of view, joint and several liability means each defendant owes a total amount and all defendants together owe the total amount that's due. Okay. If you are a plaintiff and you're operating under a fictitious business name, be sure to present evidence of having complied with the fictitious business filing. If you don't, the court has to dismiss the case. And you also need to include your declaration that you are complying. The small claims judge may, and I've done this in the past, look it up on the county website to see, in fact, if you do have a fictitious business name filing. If you don't, I have to dismiss the case. Service. Small claims cases are served just like other civil cases, except that publication is not an allowed service. Basically, personal service, substitute service, and the court can also serve by mail. Court service by mail requires a return receipt and requires a signature. That type of service by the court may seem convenient, but the problem is twofold. First, if the defendant doesn't sign the return receipt, if somebody else does, it's not good service. Second, if the signature on the return receipt can't be authenticated as the defendant's signature, for example, if you show up and the defendant does not, and you have a rental agreement with the defendant's signature on it, and if the judge can compare the signature on the rental agreement to the signature on the return receipt card and determine that they are the same or very similar, then the court may agree that there's good service. But if you look at the green receipt and you look at some other documents and they don't look similar at all, that means it's not good service, and the court will tell you you have to go back and do more service. Okay. Substitute service is allowed to a private mailbox. So you can substitute serve at a private mailbox. And what that means, you go into Kinko's if they have a mailbox, FedEx, whatever else, I think FedEx has them too. But whatever private mailbox facilities out there, you hand the person that's there a copy. They're familiar with this, so you won't be surprising them. And then you mail a copy of the complaint to the PO box at the private mailbox. But you can only use that if that's the only reasonably known address for the defendant. If you have another address for the defendant, you need to go that route. Okay, substitute service. I'm not going to go through personal service because it's pretty straightforward. Process server or whoever you have do the service hands it to the defendant, and that's personal service. Substitute service is a two-step process. Both steps have to be completed in order for service to be good. The first is you go to the house or business or as I mentioned, the mailing address for a private PO box location, and you leave a copy of the claim and order form. Then you mail a copy of the claim and order form to the same address. Both steps are required. If you don't do both steps, service is not good, and you will have to go back and do it again. Service is complete on the 10th day after mailing. And typically you have to file your proof of service 5 days before the trial. So that means in theory, you need to have your service done by substitute service not less than 15 days before the court hearing. Okay. Service is normally required to be in California. There are two basic exceptions. The first is the non-resident owner or operator of an automobile. That's a person who's operating an automobile in California but lives in another state. You can serve them by serving both the director of the Department of Motor Vehicles and the defendant. The other situation is if you have an owner of real property, land in California, but they live in another state, You can serve, and there's no designated agent for service. You can serve the non-resident owner um, out of state. And that situation is only allowed if your claim relates to the property. This is typically a landlord-tenant situation. You can serve people who live in a gated community. You have to read the code section as to how to do that, but basically you serve the guard at the gate. If there's no guard at the gate, there are procedures in the code for how to do that. Okay, as I mentioned, service of the claim has to be completed typically 15 days before the hearing date if the defendant resides in the county, in San Diego County, if that's where you're filing. If the defendant is outside the county, at least 20 days, service has to be completed at least 20 days before the hearing date. Service is deemed completed on the date the defendant signs the mail return receipt, on the date of personal service, on the 10th day after mailing for substitute service, or if you can establish service by some other competent evidence. Proof of service must be filed with the court at least 5 days before the hearing. This is a big issue with small claims court, getting the proof of service filed timely. Please don't wait until the day of the trial. It may cause problems. Okay, I'm going to repeat this probably a couple more times. Try to use a registered process server for your service. It's more expensive than using your good buddy to serve a complaint, but the registered process service carries a rebuttable presumption of validity. If you use your good buddy to do service, plan on having your good buddy, family member, or whomever it is come in and testify regarding service if there is a dispute regarding the service. If you use a registered process server, the proof of service form is generally good enough by itself to establish service occurred. The cost of service is usually from a registered process server is going to be usually in the area of about $50 to roughly $150, depending on where service is and what kind of service is required. Okay, defendants. Defendants can file a claim. If you're a plaintiff, anticipate a defendant's claim. Defendant's claims can be related to the plaintiff's claim. This is typical in landlord-tenant. Landlord sues tenant for unpaid rent. Tenant sues landlord for habitability issues or security deposit issues. Tenant sues landlord for security deposit. Tenant claims landlord deducted too much from the security deposit or made deductions they shouldn't have made. Then landlord files a claim against the tenant for unpaid rent or damages or other things that are not part of the security deposit. Okay, so if you're a plaintiff, you can anticipate a defendant's claim. If you're a defendant, be sure to get your defendant claims filed timely. Okay, if you're a plaintiff and you sue a defendant and this defendant and you had some other relationship or event occur, that defendant can sue you for things not related to the plaintiff's claim. So if you sue a defendant for an automobile collision and the defendant says, I loaned you my lawnmower 2 years ago and you didn't return it, so I'm going to sue you for the value of the lawnmower, that's allowed in small claims. Whether it's appropriate, it's another issue, but that is an allowed claim. Small claims does not have compulsory cross complaints. So if the defendant does not sue you in the small claims case, the defendant can still file a small claims case against you later. The defendant's claim needs to be served at least 5 days before the hearing date. If the defendant was served less than 10 days before the hearing date, then the defendant's claim has to be served at least 1 day before the hearing date. My experience is if you have late service on that, the case is going to be continued because either the plaintiff or the defendant is going to want some additional time. But if neither wants additional time and you're ready to go to trial, the court will hear it on that date. Okay, consolidation, severance, and coordination, and request to transfer action. These are other things that can happen to a small claims case. In terms of transfer of action, if a plaintiff sues a defendant may have another claim against the plaintiff that is greater than the jurisdictional limit for small claims court. The defendant can file a limited civil case or an unlimited civil case, then ask the small claims judge to transfer the small claims case to the limited or unlimited case. If the small claims judge agrees, your small claims case will be transferred to another court, another department, and the small claims case and the defendant's limited or unlimited case will be heard at the same time. The transfer request procedure requires various forms to be filed. If you're a defendant and you're wanting to do that, be sure to fill out the forms and file them with the court timely. Typically, these are done on the day of the trial, but be sure you get everything ready to go to present to the small claims judge. If you need to amend the claim, if you're a plaintiff and you haven't served it, do your amendment, and then refile with the amended claim. If you've already if you've already served the complaint and you want to amend, you can either do that at the time of the trial, which may result in the trial being continued, or if it's an amendment that doesn't need a continuance in the trial, for example, you misspelled the defendant's name, or you have the wrong name for the defendant, you have John Smith, and the person you think is John Smith is actually John Stevens, but John Stevens shows up, the claim can be amended at the time of the trial. Small claims also have a procedure allowing for pretrial orders. These are requests by either the plaintiff or the defendant before trial, asking the court to do something or order something. Typically, these would be situations where the plaintiff or defendant wants the other side to produce some sort of document at the time of trial. If you do have a request for that, you file it with the court. The court will allow the other side an opportunity to respond, and then the court will make a decision as to the request. If you need to postpone the hearing, you can request the postponement. They prefer that you do it sooner rather than later. A lot of the times, majority of the times, it's done on the day of the trial. If the other side doesn't object, the trial can be continued. If you wait till the day of the trial, the court may not allow you to postpone it unless you have a good reason for the postponement, especially if the defendant is there and ready to go. If you're a plaintiff, you need to dismiss the case for whatever reason, again, do this sooner rather than later. Try not to wait to the day of the trial. Normally, you will have to file a request for dismissal with the case. If you decide on the day of the trial you want to dismiss the case, you can do that in front of the judge. It's called putting it on the record. Okay. People allowed to talk at the time of the trial. Typically, the only people allowed to talk at the time of the trial are the plaintiff, the defendant, and witnesses. Corporations can appear through an employee as long as the employee is not retained to appear in small claims court. This is typically a business that sends somebody over that handles like collection cases, suing on behalf of the business, that type of thing. If you're not a corporation or a natural person, a human being, for example, if you have a partnership, you can have some other officer or director for that business to show up and testify. Again, as long as they're not employed to appear in small claims court. An individual sole proprietorship can have somebody else show up as long as the claim relates to business documents that can be proven solely by the business documents. These would be typically claims where a business says somebody owes them money. Management can appear on behalf of a homeowner association, and an owner of real property can have their property manager appear as long as there's a contract allowing the property manager to represent the property owner. Okay, how do you present your case? This is really the important things to think about when you're going to present your case. The procedural items I've already gone through are really important. And if you have questions, download the forms from the court. The court, I believe, has a small claims advisor available. I don't know if it's in person yet or not. You may be able to call in and get information. There's a lot of information available regarding small claims at the court website and through the Judicial Council. Try not to use the internet as your legal reference tool because a lot of times it's outdated, and sometimes just flat out wrong. Okay, now day of the trial or the day before the trial, hopefully not the day before, but these are things that you should be ready to do when you do your trial. Most important is be prepared. Don't wait till 5 minutes before the virtual hearing starts or 5 minutes before you walk into the courtroom to get your documents together and ready to go. Be prepared, have reviewed everything, be ready to answer questions from the judge. Okay, first thing you should do is make sure you know what you got to prove. If you don't know what you have to prove in your case, get some knowledgeable assistance. The University of Google Law School is not a real law school. Do not rely on the internet for your legal research. Again, it may be out of date or wrong, or you may not be, and it's typically the case, you're not getting all of the information. If you have a contract action, make sure you understand what a contract is, how it's created, when it's breached, and what damages there are. If you're a personal injury case, make sure you understand negligence or an intentional act like assault and battery. Make sure these are what are called elements of the cause of action, what attorneys refer to elements, the various things you have to show in order to succeed in small claims court. You do not have to be an attorney, and the small claims judges will typically ask questions to help flesh out things that you don't mention. It's something that I would do during small claims. I would ask somebody, for example, in a contract action, what did you promise to do? What did they promise to do? Did they do what they promised? Did they not do what they promised? When did they promise to do what they were going to do? How much did they promise to pay you? When did they promise to pay you? Did you ask them to pay? What was their response? Those are the kind of questions I may ask. But if the judge doesn't ask those questions, be prepared to talk about them before the judge asks the questions. And if you can, have a little outline with these list of points you need to make. Okay, think about your case before you get to court. Don't think about it, while you're standing there or sitting there. Think about it before you get to court. So understand what your case is. Think about what the other side's going to say. Think about how you're going to respond to what they say. In most small claims cases, people have some sort of interaction with the other side over a period of time. There's usually a dispute. There's usually people saying, I'm right, you're wrong, I'm right, kind of thing. So you should know what the other side's going to say. Be prepared to respond to what they say. Small claims is informal, but not casual. Unlike TV, the judges in small claims court keep a tight rein on the litigants, and they will not let you make snide comments or rude comments about anybody. My response sometimes when people are getting a little mean is, I ask people, are you trying to prove your case or are you trying to lose your case? And that usually wakes them up pretty quick. Okay. Don't argue with the other side or the judge. You're not going to win the argument, so don't try. Be brief, be to the point, discuss facts. Facts are what the judge is looking for. Opinions generally are not what the court's looking for. They want to know facts. They don't want to know what you think about the intelligence of the other side. Okay? Avoid telling the story. People want to start with, well, Your Honor, we met when we were in third grade and I got to know them really well and I really trusted them and I did this and they did that and we got along really long. And this is, judges don't want to hear that. They don't have the time to hear that. And if it isn't relevant to the issues, don't spend your time doing it. The judge may interrupt you and say, we need facts. We need to know what we're talking about today, not what happened 20 or 30 years ago. Okay. Do not say it's in the file. Okay. It's one of the things I did not like as a pro tem. I know it's in the file. Tell me where it's in the file. If you got a document that you want me to look at, tell me specifically where to look, which document and where in the document. So know your evidence. Help the judge out. Be organized. Have everything ready to go. Put it in a manner that lets you find things quickly. Okay. Don't repeat multiple points multiple times. It's annoying. In virtual world, this isn't really that important, but when we get back to in-person trials, keep in mind a thicker stack of documents doesn't mean you have better proof. Helpful to the judge is label your documents. For virtual trials, you're required to put exhibits on it. I recommend exhibits that aren't exhibit A or exhibit B or exhibit 1. Put exhibit names like garden photographs, vehicle photographs, something like that that makes it easy for the judge to immediately know what they're looking for. Judge asks you a question, respond directly. If the answer is yes, say yes and stop. If the answer is no, say no and stop. Don't start trying to explain things. If the judge wants additional information, he or she will ask you. If you need to add in additional information, you will probably get some time to discuss that. Admit the obvious. Judges are generally old folks like me. They've been around a while. They've heard from hundreds, if not thousands of people. And if you're asked, does the sun rise in the east, and you won't admit that, that's going to mean your credibility is pretty slim. Judges like honesty. If you don't know what the judge is asking, say, I don't understand. Please clarify. This is really kind of important. Know what you're claiming and know how you got to that amount. Consistently, people walk in and say, they owe me $5,000. Why? Well, that's the limit. But how much do you want? $5,000. How did you get that amount? That's the limit. That's not going to help the judge. If you want a specific amount of money, say that amount, explain how you got to that amount. Don't say I can get them for you. If you don't have them at the time of trial, the judge is not going to stop everything or continue the trial so you can go get another witness or another piece of document. Have everything ready to go when the trial starts. There are no forfeits in small claims. You show up as a plaintiff, the defendant's not there, you still have to prove your case. If mediation is available, take advantage of it. If you can settle the case, it's usually a better deal. You may get less or you may pay more, but it's usually better to settle and walk away than have a judgment and then you're angry at the other side and you're angry at the judge. If you have witnesses, tell them not to repeat what you said. Credibility or character witnesses are generally not allowed in civil cases, and in small claims court, if the witness purpose is, I've known this plaintiff for 20 years and they never lie, the judge is going to go, well, I'd be surprised if he came in and said, I know the plaintiff for 20 years and that's all they do, lie. So if you got a witness and they're helpful with the facts or they're helpful to explain something that you can't explain or can't provide, great, have that witness there. But don't have them come in just to make you look good. Do not read from a prepared statement. If you have notes, great. But when you start reading from a document, the judge normally will know that, and that usually means you're talking too much. I tell people, I just want to hear from your heart. Tell me what it is or why you're here today. Just give me in a short phrase why you're here today. And the usual response is, well, I'll forget something. That's fine. Tell me why you're here today. Let me ask questions to figure it out. You will give me all the information that I need to make a decision. Okay. If you need an interpreter or assistance, physical handicap of that type, let the court know as early as possible so they can prepare and have somebody available. Right now, there's a lot of Spanish interpreters as well as other languages, and it takes some time to get an interpreter, and they may not have somebody available on the day of your trial if you wait to the day of the trial. So let the court know if you need an interpreter or assistance early. Currently, the courts are doing virtual trials, and there are certain rules related to virtual trials. The court website has a very good page. Read it thoroughly and read it again and make sure you understand what the rules are for virtual trials. Some things that I found from watching virtual trials is, one, if you have the time, watch some small claim cases before your trial so you can see what other people do and how the judges handle trials. Test your computer before the day of the trial. Make sure that everything's working and you can be heard well and you can be seen well. You don't want to log in and have total breakdown of your computer system or your phone. So practice before the trial. If you can, if you're going to use video, practice with witnesses so you can see what it's like. You can learn to pause and not talk over other people. This is a big issue I've noticed in the small claims cases I've been watching recently. Get your documents to the court timely. Currently, the court requires you get documents at least 10 days ahead of trial. Submit them timely, get everything in. If you can do it at least 10 days ahead of time, do that. There are links at the court website for submitting documents. When you get your small claims case, you will be given a department. Be sure you be sure you submit your exhibits to the correct department. If you're in Department 1106, don't send them to Department 61 or 63 because Department 63 is the top one on the list. So be sure you send it to the right place. Okay. Check with the court with the most current situation regarding virtual hearings and what to do. Okay, small claims case is now over. The judge can rule from the bench or the judge may take the case under submission. A lot of judges like to rule from the bench. I like to take cases under submission. Virtually trials, a lot of the judges I've seen will rule from the bench because there's not some issues. There's not the same issues regarding parties having disputes after you rule from the bench. I can tell you from my experience in watching other cases, when there were in-person hearings and a judge ruled from the bench, there have been pushing and shoving and occasional fights out in the hallway or parking lot after the judge rules from the bench. So I normally took it under submission when it was in person. For virtual hearings, it's a different story. You'll find that most of the judges will rule from the bench. They'll make a decision and tell you what it is. Okay. The standard for evidence in civil is, in most cases, preponderance of the evidence, and that's defined as more likely than not. It's a very low standard. It just means, and you'll see judges do something like their hands and weigh it like this. And equally, when evidence is equal, the party with the preponderance, that's usually the plaintiff, will lose. So if the judge believes the evidence equally, believes both people's evidence is equal, the plaintiff is going to lose. So plaintiffs, you only have to go a little bit above 50% equal in order to win the case. So it's not a real heavy burden, but if it's equal evidence, if the judge thinks it's equal, then plaintiff will lose. Same thing with defendant. Defendant, if you can establish that or show to the court the evidence is equal, or you can show that your defense is slightly more likely than the plaintiff's evidence, then defendant, you should win. Plaintiffs, make sure you got the right name of the defendant, and if you don't, make sure it gets corrected before the judgment's entered, because a defendant, excuse me, a judgment with the wrong defendant's name is not going to get you much, and it takes a lot of time and effort to correct a judgment. So try to correct the information before the judgment's entered. If you're dealing with somebody that's an active duty military member, service member, there are special rules regarding judgments, especially default judgments. And there's a procedure that has to be followed. So if you're suing somebody you know is active duty military, there is a procedure that needs to be done in order to proceed with a lawsuit as to the active duty military person. The judge may order installment payments as part of the judgment, but that's not typical, but it is something that a judge may do. Other types of relief can be ordered. Sometimes, in some cases, the judge may need to be creative. I've had a situation where a car sale occurred and the buyer wants to return the car because it's defective. And I've worked out a situation where the buyer had to return the car by a certain date. And if the buyer didn't return the car by a certain date to the plaintiff, to the seller, then the seller would pay money. So the buyer was given the choice of keeping the car and not having a judgment for money, or returning the car, and the seller would get the car back and the seller would have to give the money. So it's a kind of situation where the parties kind of decide what the ultimate result is. And that's something judges can do in small claims court, that kind of what's called equitable or fair judgment that's out of the ordinary. It doesn't have to be money only. Once you get if it's a money judgment or any judgment, the judgment is automatically on hold. It's called staying the judgment for 30 days. That allows the party against whom the judgment is entered to request a trial de novo. That's a new trial, and have a new hearing. Parties can make what's called a request for order after judgment. Typically, this is a situation where the party that doesn't win asks the judge to reconsider the decision because they think the judge didn't get the evidence right, or didn't get the amount right, or some other particular reason. All right, post-judgment. I've already mentioned about trial de novos and appeals. In the case of a plaintiff, plaintiffs cannot appeal a decision they do not like. When a plaintiff files, they give up the right to an appeal. If a defendant does a defendant's claim, the defendant gives up the right to appeal any judgment regarding the defendant's claim. Defendants who are sued can appeal a claim against them, and in a defendant's claim, where the defendant has sued the plaintiff can appeal a judgment against the plaintiff in the defendant's claim. The result of all of this is the case is going to be heard new. It's called a trial de novo, and the trial will be a new small claims trial, but this time with a different judge. If you didn't appear at the time of the trial, a party is allowed to bring a motion to vacate the judgment. It has to be brought within 30 days. If you're doing a motion to vacate the judgment, particularly defendants, they have to have a pretty good reason why they didn't show up at the time of the trial. If the judge grants the motion to vacate the judgment, for example, plaintiff comes in, the defendant's not there, judgment's entered for plaintiff, defendant gets notice of the judgment and comes in and brings a motion to vacate and has a good reason why they were not there at the time of the trial. If both people are present, the court can vacate the judgment and do the trial right then and there that day. Or is more typically the situation, if both people are present, the court will continue the trial or set a trial 30 to 45 days down the road if the motion to vacate is granted. If the motion is not granted, if the motion to vacate is not granted, then the judgment stands. Okay, collection. Uh, Small claims court judgments are collectible in the same manner as any other civil judgment. Enforcement is stayed pending the appeal period. If there is a trial de novo, it's stayed until after the trial de novo decision. And at that point, then collection can begin. If there's no appeal, then collection can begin after 30 days. Okay. The court does not collect the judgment for you. You have to do the work. You can use the same general procedures in small claims that you can use in any other civil case: wage garnishment, levies on bank accounts, things of that type. The court mails a document called a judgment debtor's statement of assets to the party against whom a money judgment was entered. The party is supposed to fill that out and mail it to the judgment creditor. That's the party that got the judgment within, I believe it's 30 days. My experience is that's almost never done. Okay. So the methods for enforcement by small claims court include writ of execution. That would be a writ that's issued by the court, goes to the sheriff. The sheriff will levy or execute on the judgment, typically by attaching bank accounts or other things. For example, cars can be subject of levy. Personal property can be subject of levy, other things similar to that. You can have an abstract of judgment issued. That's where the court issues a document called an abstract of judgment. You record it, and that will create a lien, a judgment lien on any real property the defendant or the party against whom the money judgment's entered creates a lien on any real property they own in the county where the abstract is recorded. You can compel the party who owes you money to come to court to give you a statement under oath regarding their assets. It's called a judgment debtor examination. Okay. If the statement of assets that the court mails isn't returned, like I said, normally that doesn't happen. I've seen it a few times happen, but normally it does not. In theory, the judgment creditor, the person who has the money judgment, can ask the court to issue sanctions and an arrest. It's called a bench warrant, and attorney's fees if it's not timely returned. The court was doing bench warrants for a while. Last I heard, they have stopped doing bench warrants. Bench warrant is a situation where it goes into the police system, and if the defendant stopped or the person who owes you money is stopped for a traffic ticket, for example, and they do a search and the name comes up, in theory, the police officer could arrest the person for not timely filing the statement of assets and put them in jail pending a hearing on the arrest. Like I say, the courts, last time I heard, the courts are not doing bench warrants on most cases, especially civil judgment cases. Okay, some documents that are available at the court website. One is, I've provided two, or you have access to two of them. These are available at the court website. One is a pretrial checklist for the small claims virtual trial. It's not a complete checklist, but it's a starting point for preparing for a virtual trial. It's a 2-page document. What you're looking at right now is page number 1, and this is page number 2. It's a helpful document to look at to get you prepped for trial. And again, the two things I've noticed in virtual trials is the court is having problems with people submitting documents timely. And the other issue is technology related connections and that type of stuff. So if you're going to do a virtual trial, and that's what's going to be the norm, probably at least through July or August, and probably will continue to be available even when in-person trials are being held. Be sure to test your technology first and make sure you can get the best connection. It really makes a difference in presentation. For non-virtual trials, for in-person trials, this is also a checklist that's available at the court website. You You can use the two of them to help you prepare for trial. Um, Preparation for trial is something that you should do from the moment you file. Should get your documents organized, get them all in one spot, be ready to submit them to the court ahead of time, mark the exhibits for trial. And if you have witnesses, talk to your witnesses before trial. Tell them what you're looking for from the witness, so that they are clear and distinct and ready to talk about their particular point and ready to respond to any questions that the court may have. So that basically takes you through the exhibits I have. I'm going to go take a look and see if we have any questions to answer. Okay, and if you have anything, feel free to add as we go along.
Can you
Okay,
see those questions there? Yeah.
I can see questions. So first one I have is, in security deposit cases, is it advisable, let me make sure we got here, that all willing tenants be added as plaintiffs, or just one tenant sufficient? Okay. The more people you include as a defendant, the more potential people you have that can pay the judgment. So if you have two or more tenants, it's better to have two or more tenants, because that's two or more potential sources for money. So that is better. If you have a security deposit case and a written contract, and these tenants are joint and severally liable, you have a rental agreement that both or three or more have signed, a judgment against one is good, because that one is responsible for the full amount, but that one may not have the money to pay, at least not right away. So more is better when you've got a money judgment. One will get you going, but if you can get more, so much better, so much the better. Is finally a motion to quash an option in small claims court? That's probably related to service. You're talking about motion to quash service. There are no motions in small claims court. So if you're going to do something, you can do a request for order, a pretrial request for the order. If you're disputing whether service was done correctly or not, that will notify the court that regarding service at the time of the trial. The court, if you do a request for order prior to trial, the court may make a determination that service is not good and notify everybody, and then notify the plaintiff to reserve or do other service or do service again, and then reset the case for a different trial date. So if you have a really good feeling that the service is not good, it probably wouldn't hurt to do the pretrial request for an order. And then if service is in the file, and again, the problem here is, if the plaintiff hasn't filed the proof of service yet, the court won't have anything to make a decision on until that proof of service is filed. And you may not know what the plaintiff is saying about service until the day of the trial. And then at that point, you can bring up the service issue, have whatever evidence you need regarding service. If they're claiming substitute service or personal service, and you think they say they personally served you, and you have evidence you couldn't possibly have been served on that date, they got it wrong, bring whatever evidence you need. But there is no motion to quash. And the closest that you could go is that pretrial request for order. Something that you can do, I believe that's now available, is look at the San Diego Superior Court website. On the website, they have a box called Register of Actions. If you click on that box, there's a drop-down box that you can go to. I believe it has small claims specifically. And if you put in the case number or one of the names of the parties, you should get the small claims case. And what you should be able to see are documents that have been filed in the case. The documents may be available for downloading. So if you go to your case and there's a register of actions listing for the case and there's a proof of service filed, you should be able to download the proof of service form, see what they filed with the court, and that way you'll have a better idea as to what the plaintiff is claiming as service, and that will give you some helpful information for your issue regarding service. Okay. Is there a formal prove-up process for a plaintiff seeking a default judgment? Yes, not to be irrelevant about it, or I guess a little sarcastic about it, that's called a trial. Small claims does not have default prove-ups, even though they may call them that. In small claims court, if you're a plaintiff, you show up to do the trial. If the defendant's not there, you do the trial. If the defendant is there, you do the trial. The only difference between, well, the difference between a trial with the defendant and a trial without the defendant is, without the defendant, there's nobody there to really contest what you are saying. But that doesn't mean you're going to win. You still have to put on all of the necessary evidence to prove up your case, just like you would if the defendant's there. So like I mentioned, there's no forfeits, there's no gimmies in small claims court. As a plaintiff, you still have to prove your case. Oh, I'm sorry. Okay. Your question was related to plaintiffs, the tenants in a security deposit case. The short answer is yes. It's usually better if you have one plaintiff that's suing on a security deposit where multiple plaintiffs are involved. Normally, you want to have all of the plaintiffs involved at the same time. Small claims is subject to the same requirements of having all the necessary parties at the same time of the litigation. You may be able to get another plaintiff if they're not physically able to appear. You might be able to get a document that allows you to appear on their behalf, kind of thing. Right now with virtual hearings, they can call in or they can telephone in. But if there's two parties that are party to the contract, they should both be involved in the contract, because a judgment in that kind of situation is subject to a dispute down the road. So you want to have everybody that has a claim on whatever it is, in your case, a security deposit, present and there, and the court has jurisdiction over them. So the court's decision is binding on everybody. Okay.
Hey, Wayne.
All right, thank you, folks.
Yeah, it looks like we're winding up here. I want to thank you so much. What a great informative talk. We're going to make, Mr. Templin has been very nice in allowing us to make the PowerPoint available to you guys who have been watching, so we can send that to you if you would like. And just want to thank you very much for this presentation. We're so glad that you were able to teach us. And thank you very much to all the participants who included today.
Okay. Thank you very much for coming.
Thank you.